Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Insolvency and Bankruptcy Code 2015. To discuss the issue, I have with me Mr. Nirvaan Gupta, partner, Dua Associates, and Mr. Alok Dhir, managing partner, Dhir and Dhir Associates. But first, the highlights. The Insolvency and Bankruptcy Code 2015 makes exiting business easier in case of bankruptcy. The new code is applicable to all entities that fall within the ambit of Companies Act of 2013. And corporate insolvency applications will now have to be decided within 180 days. The Insolvency and Bankruptcy Code 2015 will replace the existing bankruptcy laws to make it easy for investors to exit within a fixed time frame to improve the ease of doing business in India. Insolvency is a situation where individuals or organizations are unable to meet their financial obligations.
There is no single law that deals with insolvency and bankruptcy. There are many different laws providing for multiple forums such as Board of Industrial and Financial Reconstruction, Debt Recovery Tribunal, and National Company Law Tribunal, and their respective appellate tribunals. Liquidation of companies is handled by the High Courts. Individual bankruptcy and insolvency is dealt separately. According to the government, the existing framework for insolvency and bankruptcy is ineffective and results in undue delays in resolution affecting business environment.
It will give one clear platform to all the creditors, partnership firms, individuals who have been facing any problem in terms of bankruptcy. And it will enhance the interest of the creditors. It will give confidence to the creditor that his money is going to be back. There would be a way of recovering the money. The process is going to be shortened. It will not be that long drawn process of going to the Debt Recovery Tribunal and other ways of doing it. So I think it's a great step forward. It is definitely going to be a great boost for the economy and for the development of the economy if the timelines which have been provided in the Act can be followed.
The provisions mentioned in the Insolvency and Bankruptcy Code 2015 will be applicable to all entities that fall within the ambit of Companies Act 2013, any company which is governed by a special act in force, Limited Liability Partnership Act 2008, also partnership firms and individuals.
For the investment sector, the underlying objective is that by reprocessing assets and businesses which are sick or insolvent, either so that the same businesses can emerge in a healthy manner, or so that there can be new owners of those businesses, and the process does not take so long that by the time the process is done, the assets have gotten completely degraded.
The bill aims at balancing the interests of the stakeholders by consolidating and amending laws related to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner, which would lead to maximization of value of the assets. The bill is expected to make it easier for sick companies to either wind up their businesses or engineer a turnaround. The bill was tabled in Lok Sabha by Finance Minister Arun Jaitley.
The introduction of Insolvency and Bankruptcy Code is being looked at as a significant step taken by the government to ease doing of business in the country. If the code turns into a law, it will provide an opportunity to the unsuccessful business ventures to start afresh. With cameraman Sanjay Kumar, Dipali Pandit for Rajya Sabha Television.
In the immediate term, the new code is expected to be a big benefit to the public sector banks, which are riddled with bad loans. It will enable them to recover their dues easier. Straight away, going to the issue, sir, the most important aspect, you pointed out that this is a huge shift from the earlier status, which was where the judicial wisdom weighed over commercial wisdom. Now, this bill takes away the position in favor of commercial wisdom and away from judicial wisdom. How do you see it?
This is a very titanic shift. Earlier we used to have debtors in possession, and the creditors had to go through the processes of DRT, etc., to recover their dues. There were various enactments like the Sick Industrial Companies Act, which were there for rescue, and then the winding up under the Companies Act. Different enactments, different processes. The entire legislation is now predicated upon the commercial wisdom. The entire process is now creditor-centric rather than debtor-centric. We are talking in terms of creditors in possession during the process of rehabilitation of the company, if it is possible, or liquidation of the company. So that is the major shift in the jurisprudence of the insolvency and bankruptcy.
Helpful
laws
or
in this
not
country.
helpful?
I would say it's a question ultimately of balance. We do not know how this will be implemented. I can only say that in discussions with various in other jurisdictions, lawyers in other jurisdictions who have for years had enactments which were creditor in possession and creditor-centric enactments, they have all confessed that it is impossible to revive a company with a creditor in possession, and they are talking in terms of how to bring back the debtor into the operations of the company.
Apprehensions remain.
Apprehensions remain.
The point that you made, I mean, there's so much of data that is involved, financial data. What about, you pointed out the confidentiality aspect. That what happens to that data? I mean, how can people lay or get right to information or can get information of something that is confidential to an entity? Is that the point you're making?
Yes. So the bankruptcy code envisions a whole generation of insolvency professionals, information utilities, and they are changing the process from a judicial process to a market-driven commercial process. We all know that we don't have a data protection law in the country, and this data which will be sitting with the information utilities, which are yet to take form and shape, and the code of conduct and the code of ethics are yet to see the light of the day. But how this financial information which they will mine from all the borrowers, be it individuals or be it corporates, and how sensitive this information may be, and it may be very sensitive because they would not be mining just for filings which have been made with the Ministry of Corporate Affairs. They would be possible disclosures a little more onerous than those, and how will those be secured and safely kept is something which is an area of concern which needs to be addressed.
So what you're saying is borrowing is a very sensitive issue for whether it be individual, company, entity, anyone. And that confidentiality of the borrowing aspects, of the debt aspect, needs to be given the treatment that is given right now.
Right.
Correct?
Right.
On the capacity building side, sir.
May I just make a comment before that? As you are aware, recently the Supreme Court has called upon the RBI to provide information relating to all defaulting borrowers with more than 500 crores of NPA.
Correct.
And the RBI's counsel came back and said that this information is not available with us and we will have to get it back from the banks. That's the challenge we are dealing with today.
Okay. On the infrastructure capacity building side, the bottlenecks.
On the infrastructure capacity building side, there are two basic, if I may say, pillars on which this entire enactment will be based. One is the insolvency professional, and the second is the insolvency utility, the information utilities. Now, the capacity building, insofar as both of these are concerned, is very, very significant and is required and is likely to take a long time before it is implemented. Nirvaan has already mentioned about the challenges relating to the information utilities. But with respect to insolvency professionals and the insolvency professional agencies, the rules and regulations as to who these insolvency professional agencies are going to be, who are going to be registered as insolvency professionals, what are the qualifications.
No indication.
There is none in this enactment, and it is left for the board to create rules, and in turn for the insolvency professional agencies to lay down guidelines, including guidelines with respect to the qualification of the insolvency professionals. This is another very important aspect. In the enactment, the insolvency professional agencies, before taking up an assignment for a CIRP, will have to give in a bond with respect to the entire assets which they are going to manage, which is there so that if there is any challenge to an act or action or inaction which has led to a loss to the entity, that can be then, the bond can be then invoked by the board, or as the case may be by the company. Now that is going to be a big challenge as to who would come forward for giving such a big bond or a guarantee with respect to the transaction that it is going to handle purely as a professional.
Any lot of apprehensions on this
Right.
part, because there's a huge shift from the earlier system, and obviously the balancing of the judicial part will have to be made. That balance you are in favor of. That judicial wisdom should have a role.
I would say that there is a balance, as we said. Clearly, the arrangement which we had in the past of judiciary running the roost, I mean, ruling the entire process, has not worked. Equally, the question of creditors, because this is predicated, as I said, upon the creditors' wisdom of taking speedy and correct decisions. In the ecosystem which is prevailing in the country, how effective or how possible that is very difficult to envision at this point of time.
You'd like to add something?
See, I'm not that critical because the present bankruptcy process in the country is broken.
Anyway, very complicated,
It is
scattered,
broken. I mean,
pieces, tatters.
Yes, because you have a plethora of legislations. There are dichotomies within those. For example, when you initiate a SARFAESI action, right, the seeker proceedings, which is the sick industrial companies proceedings, are abated. And if a creditor is able to then liquidate the assets out, then there is no point of seeker proceedings left, because you
Correct,
cannot revive anything. There is nothing to revive. So there are dichotomies within the legislations, and there are also many forums which are handling these problems. So you need one comprehensive approach, a holistic approach to resolve what is broken, and it is today, it is really broken.
So summing it up, what you're saying is, I mean, the sense that I'm getting is, it's a good step forward, but more issues need to be sorted out.
Yes.
Specifically, the apprehensions of the sector needs to be addressed, and there has to be a balance between the judicial and the commercial wisdom. Time for us now to head into a break. When we come back, the new code seeks to establish Insolvency and Bankruptcy Board of India with the power to regulate all matters relating to insolvency. Welcome back. The Insolvency and Bankruptcy Code seeks to provide for establishment of the Insolvency and Bankruptcy Board of India. The board would regulate insolvency professionals, insolvency agencies, and information entities. The central government will retain all powers of the board till all this is established.
According to the provisions of the bill, corporate insolvency applications will have to be decided within 180 days, with an option of extending it by an additional 90 days. Resolution process for companies and limited liability partnerships provides for completion of process within a maximum period of 180 days from the date of registration of the case. This period may be extended by 90 days if 75% of the financial creditors agree. There will be provision for a fast-track insolvency resolution process for companies with smaller operations. The process will have to be completed within 90 days, which may be extended if 75% of financial creditors agree.
Fundamental underpinning of any of business as a whole is that the parties you're dealing with need to be good for their money. Now, the difficulty with a bankrupt company or a company that may go bankrupt in the future is that you remain uncertain as to whether in future that company will honor its obligations or be able to pay. That uncertainty is actually priced into the value of goods and services, and therefore it becomes more expensive and people price in that risk. If you have a good bankruptcy system, the cost of doing business as well as the ease of doing business will be reduced.
According to the proposed law, the insolvency resolution process will be managed by a licensed professional. It also sets up insolvency professional agencies. These agencies will admit insolvency professionals as members and develop a code of conduct and evolve performance standards for them. It also provides for information utilities that will collect data about debtors to prevent serial defaulters from misusing the system. The bill sets up the Insolvency and Bankruptcy Board of India to act as a regulator for these utilities and professionals. The insolvency regulator, the Insolvency and Bankruptcy Board of India, will have 10 members, including representatives from the central government and Reserve Bank of India. It will register information utilities, insolvency professionals, and insolvency professional agencies under it, and regulate their functioning. The bill sets up an insolvency and bankruptcy fund which will be made of grants made by the central government, deposits by persons, and interests earned on investment made from the fund.
The whole intent of passing of the bill is to, make all the process much more simpler and easier, and strengthen the creditors, the individuals, and other people in terms of, the fact remains that insolvency doesn't really mean that the person should be completely, there's a stigma which has been attached to it. We see that people don't really come out and say that they're insolvent. The entire bankruptcy procedure was completely absent, which is very much prevalent in the West. We see there are laws which are there in the United States and elsewhere. The same aspect has been inculcated here.
The code seeks to repeal or amend nearly a dozen laws, including the Companies Act 2013, Recovery of Debts Due to Banks and Financial Institutions Act 1993, and Sikh Industrial Companies Repeal Act 2003, amongst others.
Experts believe as the code streamlines and consolidates multiple laws, it will make the process of winding up of business much easier. The code also provides for penalties for offences committed by debtors. There are separate penalties for individual and corporate insolvencies. With cameraman Sanjay Kumar, Dipali Pandit for Rajya Sabha Television.
The new code is, however, not clear on whether the old laws governing insolvency and bankruptcy are being repealed or whether they will still be applicable and how. Is that correct, sir?
Yeah. In fact, as has been possibly mentioned here, it is repealing. It will repeal or it will substitute the Sikh Industrial Companies Act. But insofar as the Companies Act is concerned, only Chapter 19 and 20 will go. Because they are the ones relating to rescue and with respect to bankruptcy. Insofar as DRT is concerned, it will stay because it is not substituting the determination of debt.
Correct, correct.
So any adjudication of debt will remain with DRT.
Okay. So it's not really clear what will remain, what will go, what will be repealed.
It is very clear insofar as the Insolvency and Bankruptcy Act is concerned, it will repeal SICA. That's all.
Okay.
And all other aspects insofar as winding up, which is liquidation, and rescue, which is in Chapter 19 and 20 of the Companies Act, will be substituted by this act.
Okay. Going back to our issue of, there's a shift in focus from the debtors to the creditors. Now, how is that going to, affect the balance or the imbalance that is there, whichever is the case?
In a way, it's required because right now, as I said earlier, the process was totally judicially driven. And at the end of the day, a company is a contract between debt and equity. Equity is running the company for almost all the time. It's only in a distressed situation that the debt contributor really takes over. And at that point in time, he has the maximum skin in the game. So decision making should be afforded to the debt contributor at that point in time. So there is nothing wrong in saying that creditors should not be given the decision making authority, which this bankruptcy code firmly places that onus onto them. The committee of creditors is the ultimate decision making authority. It has to be further approved by the adjudicating authority, which would be NCLT in cases of company. But those are not points on substantive points. Those are procedural points which they will adjudicate on.
Do you have a difference of opinion on that?
I would only say this, that the balance has to be found. The pendulum, as in India, was completely in the side of the debtors in possession. They were they were taking the decisions, and in fact, they were determining how the process of rescue and liquidation works. It has swung entirely the other way now.
Okay.
It is now diametrically a 180-degree shift. It is now the entire process is in the hands of the creditors.
Bad for the entrepreneur.
In my view, it's not good or bad. Both of them are concepts which have been applicable in different parts of the world. In my view, you have to find the right balance in the ecosystem of this country. It may be somewhere in between. Certainly, I agree with Nirvaan. You cannot have a situation where the debtor, a defaulter, continues to remain in possession and, as they say, cooks a snook at the others and says, look, I'm there.
No, but
however, at the same time,
an environment of startup in India, you know the environment in India. It's a startup. So if you allow the creditor more than extra powers.
In a
what
startup
happens-
situation, it's a absolute, because the person who's starting up the company knows the company.
So it's an
no
antithesis.
amount,
That's what
no
I-
insolvency professional can substitute it. So
Correct.
it will be a disaster. But at the same time, there is very grave need for the creditor to come back and have a say in the affairs. How much are you going to keep the debtor out of this entire process is a balance that that we have to find in this country. In other parts, as I said in the opening remark, in other parts of the world, people who have been flirting with the creditors-centric legislations are veering around to the fact that you need to have the debtor somewhere in the picture. You can't really run this show without a debtor.
Correct.
Insolvency professionals can't just one day come in and start running very complex organizations in various parts of the world.
On the, you made a point about the generation aspect. That, see, as far as the distress management of the entire bankruptcy thing is concerned, that this bill or the code tries to address.
Right.
But at the generation point, where the loans or the credit is being disbursed, there is no transparency, there is no information, and isn't the RBI really responsible for it? And shouldn't it, the RBI, get more proactive on allowing all this information so that it doesn't go to the level of bankruptcy?
Right.
The preventive so-called measure.
What we are trying to fix is we are trying to move away from a closed judiciary-based regime to a regulatory regime. A regulatory regime, by its very nature, is premised on disclosure of information, which is priced in by the market forces, right? So you're trying to do it at one end of the credit pipe, which is the distress end of the credit pipe. It also needs to be done at the initiation end of the credit pipe, which is the generation end. And if you are able to disclose, and eventually we would need to move away from loans given by banks and into a scenario where corporates are raising large chunks of money through bonds, corporate bonds, and that will reinvigorate or rather kickstart the bond market in India. And if you do that, you would need to anyways disclose everything at the initiation stage. So you will have to create a symbiotic relationship, marry these two ends, and then make it work. Otherwise, those information utilities
So what you're
would
saying
not
is
really
this-
achieve the function that they're
So
trying to
what
achieve.
you're trying to say is that this piece of policy, this part of the puzzle is not addressed, has not been addressed, is not even there's not even an attempt to look at it the way you look at it.
In India, we've already had the charges get registered. So whenever a debt is contracted in the first instance under the MCA website, the charge gets registered. So information is in public domain to that extent.
Yes.
In the information utilities which are being proposed under this enactment, all sorts of financial lending, all sorts of financial contracts with charges, etc., will now become part of the information utility. You will be required to file that information, whether it is a lender
Okay.
or it's a bond.
So
or
very
any
quickly,
other
so this needs to be addressed. The 2 points that you made, there is no notice period and there is no classification of creditors.
Yeah.
Very quickly, sir, because we
Yeah,
are running out of time.
This issue pertains to the CIRP application. At the stage when a default has occurred, an application is to be filed before the adjudicating authority. And at that stage, within 2 days, the adjudicating authority decides whether to proceed with the CIRP application or not. But there is no notice which is provided there for any creditor before filing such an application before the adjudicating authority. In my view, there would be a lot of difficulty here because bona fide disputes with respect to the debt will emerge and it will be very difficult for the adjudicating authority to decide within 2 days. And if the adjudicating authority is deciding purely on the basis of the information which has been provided in the information utility, it is a one-sided information. That is one aspect. The second is that the approval of the resolution process, the resolution package, is to be made by a committee of creditors. All financial creditors are supposed to be sitting on this committee. Now, financial creditors under the enactment include any transaction which is interest bearing. It includes lease and hire purchase. It includes derivatives. It includes counter indemnities with respect to guarantees which may have been given. Now, all these are having very different rights with respect to each other. So there are different classes of creditors within an entire enterprise.
So there has
and
to
if
be a classification
all of them
of-
bunch and sit together on the same platform, there is invariably the persons who are lower down the security ladder if they have a majority, they will try to muscle out the secured creditor, which is not a desirable practice.
You also, very quickly, the point you wanted to make, there's no threshold for,
Filing the application.
For filing,
for
yes.
filing,
Just to
yes.
add, yes.
Well, the point.
Right. So it could be a 5,000 rupee, a claim
Default.
and a default, or a claim for that matter, and it could trigger insolvency process.
That's going to make the entire process really difficult to manage, because it's not supposed to be the retail 5,000, 10,000 issues that the board has to resolve. They're bigger challenges, correct?
Right. So I mean, see, at an administrative level, they have to really think this through and sort out a lot of, and I would imagine this is going to continue to evolve, because that entire regime of insolvency professionals is not going to happen overnight. Nobody can really think through even.
So what you're saying is it's
going
a
to
good
take
start.
time. It's going to take time.
I
So they
think
may need to do it in a staggered manner, like transition
But it's a
slowly.
good start. That's what you're saying.
I think I'd like to add that they have made this very flexible as an enactment, and in all probability rules will come, because it will become impossible to implement.
Moving on, my colleague Deepali Pandit spoke to Mr. Amar Gupta, JSA Associates, and tried to get his point of view.
How will this new law affect the investment sector?
The hurdle in insolvency and liquidation proceeding has been one of the biggest hurdle in attracting foreign investment in this country. The cumbersome liquidation and winding up procedure mainly for corporations, and now newly introduced limited liability partnership, has been a great disincentive in the way of foreign investment. Which is evident from the world ranking India has in ease of doing business, which is currently at 130. I believe that this is a excellent step forward in improving the business environment. For a corporation, exiting a business is as important as entering a business, and in that direction, this will really facilitate the process. It has laid down clear-cut, coherent, consolidated procedure, time-bound procedure, which I believe will greatly encourage the foreign investment.
Do you think this code will enable speedy and fair bankruptcy processes?
In fact, the time-bound decision-making is enshrined in the code itself. For the corporations and limited liability partnerships, there is a 180-day process for insolvency reconciliation process, at the end of which the decision must be made whether the company can be rehabilitated, revived, or it should go to liquidation. This time-bound process, I hope the tribunals and courts will respect that, and the parties, the stakeholders in the company, particularly the shareholders and the creditors, they respect that and they follow that procedure.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our show on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.